Changes to family law are coming June 10th, 2025, and they will be impacting how property settlements, parenting arrangements, and financial disclosures are handled. Whether you're separating, already are in the court, or just wanting to stay informed, these updates could affect your rights, responsibilities, and how your case is managed. So we're going to go through 2 fact sheets that have been handed out by the Attorney General's website talking about the changes, and we're going to run through them and go into some depth about the things that are really relevant to you. Welcome, Mum.
Hello, Laura. Hello, everyone.
But before we get started, a reminder, this is family law for Australia. It's also family law for every state except for WA may be slightly different. So please be aware of that. And of course, Mum isn't your lawyer, so please always get independent legal advice as each situation is different. Just a reminder that this episode may be slightly triggering for people. If you feel triggered at any point, please call Lifeline. Or if you've experienced any family violence or assault, please call 1-800-RESPECT.
Hello, I'm Laura Furiosi, divorced mother of 3, and I'm here with my mother, Lynette Galvin, with 35 years' experience in family law. You're listening to the Divorce Course podcast. Through our candid discussions, we hope to help you through your divorce or de facto separation. We will be answering the most commonly asked questions and covering the stages and steps that you will face on your way to freedom.
So today's episode, we're going to cover the new rules for property settlement and how family violence can factor into that. We're also going to be talking about the changes, basically the addition of rules about companion animals, so your pets, your cats, your dogs, your fish, and whatever else. And we're also going to be talking about the duty of disclosure and the changes to that and what that means for you. And also there's a little bit of changes to children's contact centres and this new thing called less adversarial approaches to family disputes, which Mum says isn't new, it's old, but they've put it back in. Is that right, Mum?
Yeah, it's quite old and it's sort of been flying below the radar. So it's got that catchy initials of LAP. I mean, really.
Yeah. All right. But let's get into and think what most people are really interested in. And we have already done an episode a little bit on this slowly as the Parliament did the Act changes. Now the Attorney General has brought out this fact sheet that explains stuff a little bit more. And then on the 10th of June, we'll probably actually see how this comes into play. But so we're just going to go into a bit more depth of what we did last time. If you're interested in that episode, go listen to it. But today I'm going to be talking about what we're seeing on the Attorney General's fact sheets. Let's talk about property settlement, Mum.
Yeah.
So what's changing?
Well, it's massive changes, really. In a nutshell, the court is now going to be able to take into account family violence during relationship, during marriage and post-separation, family violence, coercive control, etc. The biggest changes about family violence and how it's going to be treated by the court from here on during a relationship as a factor that impacts on someone's contributions to a relationship. Another massive change is one that I'm sure everyone was thinking should have been already the law, and that is the court's going to take into account wastage by one party to the relationship during a marriage and also subsequently what happens to the property pool, who's done things to make that property pool worth less, and the court can look into that now and apply the law properly, taking that into account. It's great.
Well, let's do wastage second. Let's get into the new way that they're doing property.
Yes.
So in the fact sheet, Mum, it basically says they're going to identify property and liabilities, which I think is something that they do anyway.
Yes.
And then they're going to assess the contributions, financial and non-financial, which I thought already was happening.
Yes.
And then it said they're going to consider current and future circumstances, but they put in there including family violence and economic abuse. And then it says ensuring the financial division is just and equitable.
Yes.
So it's the only real change there that they've added in family violence and economics.
And also wastage, I think, as well.
Yes.
And what the Act is doing is what the fact sheet that the lawyers got says is that the court must consider whether they should make any order, whether it's just and equitable to make an order, and they can only make an order if they're satisfied it will be just and equitable And then they've got to, in deciding whether it's just and equitable, have a look at each party's interests at the beginning, look at their percentage, so look at their future needs and look at family violence and final split. So at every stage, the court has to consider whether they ought to make an order.
So before, they didn't consider family violence as a reason to alter property settlement.
No, that's true. They didn't. Only in very rare cases, the famous case of Kennon, Kennon, which I've put on Patreon, recorded on Patreon, that was all we had to go on to persuade the court that our client should get an additional percentage of property pool if they'd been subjected to family violence. But the bar, as I say, was very high. So the court, back in the old days, it was looking for mainly physical injuries and things that impacted your ability to work later on. Now, the court is looking at whether or not a person's family violence towards another person has made the victim's contributions so much harder, and they can make percentage splits accordingly. So what the government has done is saying to the court, yeah, that's a good idea. We like what you did in Kennon's case, but we're going to put it in here and we're going to widen it. And furthermore, we're going to require the court to consider it, okay, along with the other things that they have to do.
So currently the Family Law Act 1975, Section 4AB, definition of family violence. I'm just going to quickly read that out to anyone because they might not know what the definition currently is. And then you can tell us how slightly it's changing, but then these are the things they're going to consider when it comes to property settlement.
Yes. So it hasn't. So let's be clear. The definition of family violence, I don't think has changed in particular. Okay. We did those changes last year, but the court is causing the judges to consider it more robustly, having regard to the definition while they do a property settlement.
All right. So we've got, for the purpose of this act, family violence means violent, threatening, or other behaviour by a person that coerces or controls a member of the family, the person's family, in brackets the family member, or causes the family member to be fearful. Examples of behaviour that may constitute family violence include, but are not limited to, an assault, sexual assault, or other sexual abusive behaviour, stalking, repeated derogatory taunts, or intentional damaging or destroying property, or intentionally causing death or injury to an animal, unreasonably denying the family member the financial autonomy that he or she otherwise would have had, unreasonably withholding financial support needed to meet the reasonable living expenses of that family member or his or her child at the time when the family member is entirely predominantly dependent on the person for financial support, preventing the family member from making or keeping connections with his or her family or culture, and lawfully depriving the family member from their family or their liberties. For the purpose of this act, if the child is exposed to family violence, if the child hears or sees family violence, otherwise experiences it or the effects of it. And examples of that may constitute, example, overhearing threats of death or personal injury by the member of the child's family towards another member, seeing or hearing an assault of a member by another member,
Comforting, yes.
Comforting or providing assistance to the member who's been assaulted, cleaning up the site after an assault has occurred or damage to property has occurred, or being present when the police or ambulance are occurred after an incident involving an assault. So that's the definition of family violence, which is horrific in itself. And if anyone has experienced that, I am beyond sorry that you even have to listen to that, let alone experience it. But so the court, Mum, as of the 10th of June, is going to look at all of that and see whether or not they deserve more property.
The victim deserves more property. Yes. That's in a nutshell, Rose. That's exactly what it is. I mean, it's traumatic reading the definition of abuse. But, you know, we didn't really have a very substantive definition of family violence beforehand. And it's only 20 years since it would be, well, where are your bruises? You know, well, so I think this is an understanding of what people are going through. It's got, the judges have got something to refer to in the definition, so that it's not just discretion necessarily. They can refer to it. People can make submissions about family violence, and the court now looks at coercive control as a pattern, because the financial abuse is usually a form of coercive control. And so it's really good that comes into the property settlement regime. It has never really been part of the law before because, like I said, Canon was so rarely used. So we're going to have to see how the judges apply the new legislation and what cases are coming out of it and what rough percentages. Because, as you know, when a lawyer hears, they're talking to you, they're taking notes about your case, they have a wealth of knowledge about how the court has treated these sort of things in the past. But this is a new law. So I'm excited. I'm very excited about it. I think that people who can control themselves, okay, so a lot of family violence, the person controls themselves when they're at work or in public and they come home and they rampage. So those people who can control themselves outside may well have to start learning to control themselves inside the marriage or relation or cohabitation. Otherwise, they're going to get slaughtered with property. So let's hope that's the effect. And if not, let's hope that the victims get some sort of compensation for moving forward. And I think personally, an understanding and recognition that all of those things of family violence is important for people.
I also think, particularly if you're going into a family courtroom in front of a judge to do your property settlement, if it's just property settlement, in the past they would say, oh, there's no point bringing up family violence. What's the point? It doesn't affect your property settlement. So when you go in front of a judge, the judge doesn't know that the person on the other side is a piece of crap. And that kind of behaviour and disrespect and just downright lack of care of that other person will seep through in the way they hide their money and their assets and do all of that stuff. And we're going to get to that disclosure stuff in a minute as well. But I think it's a great win for everyone everywhere. And Mum, I hope you're right that it is going to reduce the violence that occurs as the message gets out that this is going to affect property settlement. I really do hope that. I have heard arguments the other way around, but I'm hoping you're right. So let's get into wastage.
Can I just make one more comment, though, on that? That definition of family violence is no surprise to me, and it's no surprise to you, because we have been talking to people for years now, and we know what's been going on. And of course it's been family violence. But now it's in the legislation. Now those lawyers who aren't sort of in constant touch with people going through this, who are black letter lawyers, they are now going to have those factors as part of the things they have to take notice of. And the reason the court does all those definitions is really so a layperson can go, oh yes. But I think also there are some lawyers who would be unable to understand the family violence unless there were examples. Okay.
Yes.
But it's not only those things, but at least now it's in black and white.
And I think we should point out we've got a really good episode called Legal Gatekeeping. Is your lawyer gatekeeping your case? And that's going to be more relevant now than ever moving forwards for property, because we get so many people. So you've got to be really careful that your lawyer is listening to you and is telling your story, even now more so for property as well, that the aspects of the family violence you may have experienced, whilst they may minimize it, like Mum said, because they've never experienced, they don't understand, or they don't want to deal with it, you need to make sure that your story is being told. So go listen to that episode if you're up against a lawyer like that. Now let's get into wastage, Mum, because this one makes you excited. And in our Q&As with our members, in the past, it's kind of been pretty sad. And we've always had to tell them sad stories about wastage.
You know, all that money you've saved up post-separation, well, yeah, that goes in the property pool.
Yes.
So that's what we used to say. And even as a lawyer and an officer of the court, as I am because I'm admitted in the High Court of Australia as a family lawyer, even I choked on saying that to people. It doesn't matter what's happened. If you've saved up, it's part of the property pool. Or if they've blown the money.
Because that was always the case. There'd be one ex would go on 7 holidays overseas, go to Africa, go to Thailand, go, I don't know, all these exotic locations and spend all their money in 5-star hotels and resorts and business class, first class flights. the other person with maybe the children is saving and scrimping because they know they've got to start paying for school shoes and uniforms and all this sort of stuff that they know they're not going to get any help from that other
Yes.
person.
Yeah.
And then when it came to property settlement, that holiday flights and nonsense doesn't even get included. But the money that the poor person has had to scrimp and save does get split up. That was so unfair. So, Mum, what do these changes mean? And what can we tell everyone now that is good news?
Okay, so the good news is, in addition to considering the family violence, they are also able to consider what's been going on during the marriage in terms of support and finances and wastage, and what's been going on since separation in terms of wastage. So I think the court will need to take like a snapshot of what things were at separation, which is really, really different to how we've been dealing with family law property ever since 1975. We would always take the property as it was on the day that we found, on the day the court had to make the decision, that was locked in. And there was no relevance in what it was worth at separation and what money existed at separation. There was always a little bit of requirement if someone's nicked $40,000 out of the offset account. They would have to show they spent that on reasonable living expenses. Otherwise, there was a risk some of it went back. But it was a particular argument you had to make. And wastage the court was very worried about floodgates opening, like with everyone wanting to argue it. They were very worried about if people were gambling during the relationship. And you tried to show that to the court would go, well, that was during the marriage. What's that? So this is massive. And these would be the things, Laura, that you and I, like me as a lawyer and you as a layperson, when you listen to people and in our course Q&As, it used to be so hard to say, no, it doesn't matter what it was worth when you each left. It only matters what it is today. And it's much more common sense.
So let me ask an example there. Basically, the courts are going to consider if a party, so if your ex, has recklessly diminished the asset pool. So, for example, say you've separated, you're waiting for property settlement, and they take all the money out of the offset account, go down to the casino and bet it all on black, and they lose it all. Like, what happens now as opposed to what would have happened before?
All right, well, what happens now is that instead of the court looking at that case of Weir and Townsend, which was the premature distribution of assets, they used to call it, and it would be factored in a percentagey thing, you had to separately raise it. Now, the court will quantify. They'll absolutely want to know what was there at the date of separation and what's happened to this money. If that, say, $40,000 out of the offset account's been blown at one of the casinos by one person, instead of them going, like that shrugging, now the court's going to go, yes, we will add that back, just like we did in the case of Weir, just like we did in the case of Townsend, which our members know about. We're going to add that back into the pool. So suddenly, if you had $100,000 in assets and this it was 140 until they wasted it, the court's going to say, look, that 40,000 that you blew, we're going to add that back in as a notional asset. We're going to divide it up and say, well, that added together, so it's $140,000 worth of assets. And we're going to, if you're going 50-50, for example, just for my math's sake, okay, then each of you should get $70,000. But you've had $100,000 because you're adding in, they've already had their first $100,000. They're going to have to pay you back $30,000,
Right.
And if they had actually, let's say the property pool was $300,000 and they blew the $40,000. So now it's a property pool of $260,000. The court will add back that imaginary $40,000. That's $300,000. It's $150,000 each, but you've already had your $40,000. Sorry, so this is what we're going to give you back. So it just gets taken off their share.
So basically, in a nutshell, if your ex takes money out after separation, does something stupid with it, the court is more likely going to look at it as they've already taken their share.
Yeah.
Whether it's there or not,
Yes.
whether they've spent it all, wasted it all or not, they've taken their share.
Well, they've taken a share that comes out of what their ultimate share is. But that's not the only thing about wastage, Laura. The court can also look back at what happened during the marriage. And
Oh, wow.
yes, during the relationship. And I remember my very first family law case ever back in 1981 that I was involved in. The lady was so upset because her husband started an ostrich farm and she didn't want him to. And she was beside herself because the property was like, it was heading for nowhere and they had a very profitable cane farm. And so she actually left him so that they could have a property settlement before he blew all his money on this stupid project. So, you know, and she said, good luck with that. If it works, you can keep the profits. And if it fails, it's on you.
But now, if she'd said, I didn't want him to buy the ostrich farm during the marriage, but he did anyway.
And here's the proof.
Yeah.
He was headstrong or he did it. First I knew about it, he'd already done it. And it was
Yeah.
a dumb idea, you know, then it may get taken into account. Up until now, the court would say, well, if it had been a success, you'd have wanted to have a share of that. And that's how they used to fob it off. And they used to use that swings and roundabouts sort of story. So there will have to be, I think, some element of an individual acting alone and to the detriment of the property pool. It can't be something where, say, you're both developers and you're developing things, but you're a stay-at-home mum as well, and they go off and make a bad investment. I don't think that counts. It's going to have to be some unilateral thing. Your casino idea was perfect. That's the sort of thing I think that the court is looking at.
Okay, so that's good news. I hate saying that animals are property, but I guess they are. So we'll talk about animals in property settlement as well.
Yeah.
So, and we have touched on this before, but pets are now going to be treated separately as companion animals, not just property, which is good.
Well, they are property. Like the court has the power to deal with property.
But the courts will consider factors like attachment and the ability to care for the pets. And there'll be no shared cared orders for animals. Only one person's going to be awarded ownership.
And they're not going to make orders for spending time with or anything like that. I think this has come out of the inquiry into family violence and the number of times that a person who is awful, that they will be violent to their family, has no hesitation in extending that to the pets of the family. And they can use the pet as a manipulative tool. And so I think it's come about because of the family violence components.
And you do see that definition in there, a harm to a pet or death to a pet. So that is in the definition in the Family Law Act as well. So that is good news for people.
But how are you going to prove that the animal is more attached to you than to the other person? Are we going to have independent, you know what I mean? It's going to be tricky.
I think it means if you've got children who are attached to the animal or if you're more attached to the animal.
No.
Not the other way round.
No, they're not going to make an order that the children have the animal. It's
but I don't think they're considering attachment based on the dog or the cat. I think I think it's more if you're the one who has all the photos with the cat. It's obviously you're more attached to the cat. If they've got no photos of the cat. Do you know what I mean? Isn't it going to be more like that?
Maybe.
I think it's going to be more proving, like, you're the one that takes them for walks. You're the one that feeds them. That kind of thing. I don't know.
And we'll find out because wouldn't it be the case that the animal will react badly to the person who's been violent to them? You know, so it's property. It gets dealt with under the property pool. I don't think they give them a value, but before it was just nothing. Unless they were registered pedigreed with a dollar value, then they couldn't be devoted. But no, I think that there are families with no children who are desperately attached to their pets.
Yeah.
And a person who wants to exert control or make a person miserable might claim that animal for their own as a way of hurting somebody.
Yeah. Oh, look, and there's also families with children who are desperately attached to their animals. And and it's a manipulative tool to get them to come and stay at the other person's house because they're like, well, I've got, Old Yellow, and if you don't come stay with me, Old Yellow is going to cry. And here's a photo of Old Yellow crying. So there's a whole lot of...
I've heard it worse. I've got Old Yellow here, but if you don't come over, I'm going to make him sleep outside for the weekend or something like that. Like, yeah, that's so cruel, manipulative, and shows a very weird mind. But there's a very high correlation between harm to animals by a person and their propensity for violence.
Now, I just want to point out to everyone, you might be thinking, well, that's not very clear. That makes no sense. I don't know, how's that going to work? The thing is, we don't know yet.
No.
This is like the next bit of information that we received through the Attorney General's website. This is the next little bit. Mum did try and watch his video, but you nearly fell asleep.
Don't say that out loud. I did it. I've attached it to our new course, though, so anyone's welcome to have a look. But,
Yes. The new course isn't out yet.
yeah.
But yeah, so I think it's important to note that this is all we've got at the moment.
Yeah.
So please don't write and ask for more details because we don't know yet. When we do, we will know. Now, Mum,
yeah.
great news.
Tell me.
Financial disclosure.
Yes.
The amount of episodes we have done where Johnny won't do his disclosure or Mary's hiding all this stuff. How the heck am I supposed? There's disclosure delays and I'm pulling my hair out.
Yep.
So the new mandatory duty of disclosure, it's that separating couples must disclose all relevant financial information. That's always been the case, so I don't know why they're saying that's new. But non-compliance can lead to cost orders, fines or imprisonment.
Always
or
has been the case.
Adverse court decisions. So can you tell me...
I'll tell you what's
Okay.
You're invited to our free webinar. Whether you're stuck at the beginning of deciding to divorce or you're struggling to find your way through the legal jargon and fear of the unknown of the legal process, we are here to empower you to take control. Join us to learn what steps you can take, followed by a live Q&A where you get Lynn, my amazing mum, and family law accredited specialist to answer your question. All you have to do is go to www.thedivorcecourse.com.au and click on Reserve My Seat. We'll see you there. Hurry, spaces are limited, so don't miss out. Register today.
The new mandatory duty of disclosure, it's that separating couples must disclose all relevant financial information. That's always been the case, so I don't know why they're saying that's new. But non-compliance can lead to cost orders, fines or imprisonment.
Always
or
has been the case.
Adverse court decisions. So can you tell me...
I'll tell you what's
Okay, please tell us.
It's always been practically a hanging offence not to make disclosure in the court. You'd be hit with cost orders. The court may form a very poor view of you at the trial and punish you in percentages, etc. This one makes the lawyers and the mediators, we've got an obligation to make our clients aware that they have an obligation to make full disclosure. And we need to inform them about their duty of disclosure and what might happen if they don't disclose. And in the central practice direction, it's made very clear already if the clients are not going to abide by the rules of the court and the disclosure, then the lawyers should consider their position as officers of the court. And it says straight out and should take the appropriate action, including no longer acting for that party. So what we've got now is you're going to have their own lawyer pushing you to make disclosure. And if they get wind that it's not accurate, they will leave you unrepresented. So that's going to be great.
Okay. So just a reminder to anyone who doesn't know what a central practice direction is, I think we've done a really good episode on it, but you can download it. I'll put it in the show notes. It's pretty much the guide that lawyers use on what to do next. What happens?
Everything. Yeah.
It's everything.
And
but
it's
actually not like a giant book. It's only like 40 pages long. So if you're going through this process, download it, read it, and get your head wrapped around it. So Mum, you're saying, and this is where I think the wheels fall off. You're saying, and I know some lawyers out there,
Yes.
they just want to win.
Yeah.
You're saying there's going to be lawyers out there who are going to get rid of clients if they don't do disclosure.
Let's be clear. I have always let a client go if they don't make disclosure properly. I've always done that. And most reputable lawyers I would have thought would, because you're an officer of the court and they're not complying. The people who do sort of turn a blind eye because their client's wealthy or because they're mates or because they're happy enough to just be the cat's paw for the person who doesn't want to make disclosure. The one thing they want more than the money from that client or the prestige from that client is their practicing certificate. And they really want their practicing certificate to keep going. And they're not going to put their livelihoods on the line, I suggest, just for someone who's trying to fiddle the system.
Right. So are you saying judges are going to get mad at lawyers?
They already are. They already are. And they are making cost orders against lawyers. So in their own pocket. They've always had the power. But since 2021, when that practice direction came out, the court is more open to making orders against the lawyers. And this will make the substantive point that non-disclosure means you are in trouble with the court. You may be in contempt of court, it says.
Right. So lawyers must inform their clients about their duty of disclosure and the consequences of non-compliance. And you're saying, does it say it in the fact sheet that they should get rid of their client if they're not doing the right thing?
No, it says that consequence of non-compliant with the duty of disclosure includes punishment or contempt of court with fine or imprisonment. That's not the lawyer, that's the client. Okay.
Yes.
Cost orders against a party or the court taking the non-compliance into account when making their orders. The practice direction talks about that the court expects us to stop acting.
Okay.
And what they've done in this with the duty of disclosure, I believe they've elevated it now into the orders rather than a rule.
Right.
Yeah.
Okay. So if you are confused about disclosure, interested about disclosure, or about to do disclosure, go listen to our disclosure episodes. We have a really good disclosure checklist that will help you get all your ducks in a row because it can be very overwhelming. So go and listen to those episodes and download that checklist. Now, Mum, there are a couple of other things.
Okay, I can
and we're
hardly
running
wait.
out of time.
Okay.
So parenting arrangements and contact centres.
So I think this contact centre thing, they wanted to get it through at the last lot when they made all the changes for children in the 2023 legislation that came into on the 6th of May. But now it's been approved by the government, as you say, in 29th of November, received royal assent on the 10th of December from the Attorney General, and we're having this change from the 10th of June. So now it's a thing, okay?
Okay. So we've got, and we have talked about this before, and we'll touch on this really quickly. Children's contact services have to be accredited.
Yes, hallelujah.
Yay.
And they're also, part of that accreditation law is going to be intensive training about what coercive control looks like, what family violence looks like. I think it's designed so that, and I apologise to anyone who works at a contact centre and doesn't think this applies to them, maybe it doesn't, but if there are very careful, coercive control, sneaky, manipulative people that in front of a person at a contact centre for a couple of hours a week, they can be on their very best behaviour. And that's all that the supervisor sees, this wonderful person doing all these things. And so they can become a little bit one-eyed about what's going on because it's just human nature, isn't it? They tend to take the side of the person they see engaging with the little child and think the other parent may be overdoing it a bit. And I think this accreditation, this emphasis on training about family violence, and also just in general keeping an eye on it, is going to stop any cowboy operations opening up in the future. They've got to have things in place now for safety of the people as well. It's quite a long list, and I'm really pleased. Good.
And the confidentiality and the safety is really important. But let's move on to the less adversarial approach. Now, this is new.
Yes.
But it's not new. So courts can now apply for a less formal process for property and financial disputes, not just parenting matters. And the emphasis on reducing stress and intimidation in court. Can you please explain to me what the heck a less adversarial approach is?
Yeah. Well, it's where a judge can take control of your case and try to minimise the intimidating process of the court, I guess. They can help make it go through quicker. They can direct people what material to file and so forth. They can sometimes use technology to help minimize the stress for people and to keep their costs down, I guess. Previously, it could only be applied to children's matters only. And now they're going to be able to apply it to ones that include some children's matters. Okay?
Right. So
And it will automatically apply.
So you're saying in the old days, the judges could kind of be like, hey, maybe you should apply for this.
Yeah.
Or maybe you should file this.
Yeah.
Now that's going to be for property as well.
A little bit for property as well. So it used to be for children's matters.
Yeah.
Now it automatically applies for children's matters. So you're going to find a lot less, hopefully, kind of red tape to get to the nub of what's wrong with these cases and what's going on in the family. But if there's any property in it as well, then the adversarial approach will apply for the kids' stuff, and the less adversarial approach for the kids, and the other way is just normal for property, the normal process. But if everyone agrees, then it can be the less adversarial approach.
What if that just is sitting around the table with a judge instead of being in the court?
No. So what it used to mean was that right from the beginning, you would have someone engage with your case, really read everything, try and work out what's what, give little directions along the way. I mean, you'd go to court and it used to be almost like the first day of trial, your first day turning up, where they would be able to take evidence and make little decisions about the case as it went along. It was hard to understand where you were at with these things. And I think they will do it slightly differently this time. And not least of which, because every single children's matter is going to be, if it's only children, is automatically going to be less adversarial. And every single property and children's matter, the children component will be less adversarial process as well. So I think the court is really focusing on the best interests of the children. I think that it will allow them to identify any post-separation abuse, systems abuse issues. And the Chief Justice, I hope he never knows that I found his video less than riveting, but he, I think, has his heart set on getting people through with less damage psychologically.
All right. So good on them for trying to make things less stressful and intimidating, and good luck, because doesn't matter what you do, it's going to be stressful and intimidating. But let's get on to this really important point, Mum, and we get asked this question a lot. If I'm already in court, does this apply to me?
Probably. How's that for a lawyer, answer Laura? So here's the thing. It applies. I've got a little cheat sheet here.
In the fact sheet.
It'll apply. Oh, well, you tell them. Yeah.
These changes will apply to your case unless your final hearing has commenced before June 10th, 2025.
That's right. So if you don't have a hearing date before then, and let's face it, we're recording this only a couple of months before the legislation comes in. So everyone pretty well listening now who files new will be under the new process.
And let's just clarify, a hearing, they're talking about your final hearing, so that's the trial. So there's like 3 or 4 court events before that time. So you might have a hearing, but it's not your final hearing. So even if you've been in front of a judge once or twice, if it's not your end result hearing, then these laws will still apply to you, which is great. And I think some other things we need to point out is, if you are right at the start and you're listening to this, be really aware of your disclosure obligations. You do not want to be seen as a financial abusing, economic abuse or disclosure denier just because you were stressed and unorganized, because the penalties are going to be more severe. And on top of that, anybody else who's listening, family violence is really going to be looked at. And that doesn't just mean the physical stuff. It's also the verbal abuse, it's the put downs, it's the harassment. It's all those things we read plus more. Yep. It's the control. So have a look at what you're writing and saying and doing to your ex and your co-parent. How are you communicating with them? Could that be seen as family violence, harassment, stalking, put downs? If you're calling them names, if you're, being not flexible and really trying to manipulate situations, you might not be aware that you're doing it. You might just be really freaking mad at your ex because they're horrible people. or they did something horrible to you, or they're bad people, but you do not want this to be turned the other way and you be seen as the abuser. So watch what you're writing, watch what you're saying, because it's really going to matter more than ever before.
And one thing I think we should add, Rose, about when all these new laws will apply. Sure, your trial might not be until after this starts and it'll apply, but your evidence that you have been putting in since the beginning of your case, or you might just start putting into court, your affidavits and your notices of risk and all of that, from now, they should be referring to the stuff that's going to be relevant for the final hearing, because you don't want to arrive at the final hearing and you've got your final affidavit, which does have all of that stuff in, but you haven't sort of mentioned family violence before, because as you say, Laura, you're limited to pages, how many pages on an interim matter, and your lawyer might be saying, look, no, don't mention that. It just muddies the waters. You've got to speak your truth. So while I think that it would be great to do a podcast about, do you think your lawyer's wrong? Do you think your lawyer's wrong?
Okay.
Because people who do the course or have been listening to us have a very good idea, I think, of what's what. And if their lawyer is stuck in the pre-2021 days or before this legislation, hasn't properly trained themselves, I can tell you and our listeners that as we speak, there is intensive training going on. I know the court is training everyone there. I dare say anyone in a contact centre employment situation is getting training as well. And the solicitors are getting, and the barristers are all getting trained about how these new laws will apply. And I hope it sinks in. But if you get someone who says, like you suggested before, oh, don't put that in, it's not really family violence, but, it's that pattern of behaviour, you might think your lawyer's wrong.
Okay. So we might need to do that next episode.
Okay.
I also think another question you need to be asking yourself based on all of this is, am I causing economic abuse? Have a look.
Yes.
If you are the breadwinner, if you are the person who makes all the money, the other person is solely reliant on you, look at the definitions of family violence and make sure, yes, they may be manipulating the system and making you pay more than it's not fair, but you do not want to be seen as the economically abusive partner. So make sure that you're doing the right things until property settlement, so that, the whole way through, always doing the right thing. But don't be like, no, that's my money, you don't get anything now, and cut them off. And then they're like destitute until property settlement, because that's going to bite you in the bottom as well.
And they could be destitute until they bring an interim application to the court, and you either give in at the door of the court or the court orders that you pay. You'll have wasted not only your money on your lawyer, you may be for costs for the other person. I mean, be reasonable. You've got to be reasonable.
Yeah. So, Mum, in summary, and look, once there are cases, as we've talked about, when cases come out, we will talk about the changes and how it's going in the courts. But just to recap, the current changes are about property settlement and financial abuse, companion animals, financial disclosure, and parenting arrangements. Yes?
The big one.
What? Wastage.
Protected confidences.
Okay, that wasn't mentioned in his little spreadsheet.
Oh, it is.
I have to do a protected confidence one.
Yeah.
But so final thoughts is these changes are designed to create, apparently, a more fair and transparent system, particularly around economic abuse and shared parental responsibilities and understanding your obligations. So I think this is really, like you said, Mum, I think they've looked at family violence, they've looked at coercive control, economic abuse, and they're trying to fix it up. They're trying to fix the system. If you are going through that right now, go and listen to some of our other episodes on how this can help you. And we wish everybody the best, as always. We have another episode where we talked about the changes that happened last year. And of course, we will continue to update you. If you want to look at these fact sheets, there's actually 3. There's one that's in like picture graphs, like emojis and stuff.
Right.
So it's really dumbed down.
And it's in many languages too.
Yes. So I'll put the link to that. I'll put the legal professions one in as well, in case you want to read their stuff. And I'll also put it in the one written for lay people so you can have a look at all of it.
So we've really only scratched the surface of what wastage will mean as well and things, but there's also another element, and that is the protected confidences where a person can raise the issue with a judge. It, I think, is going to need to be maybe in another episode because there's a lot to it.
Right.
But it's generally referring to subpoenas being issued to your psychologist or your kid's psychologist or psychiatrist, and how the court is going to deal with those and stop people using them against a person in court. It's
You know,
shocking.
that's not in the fact sheet for normal people.
For normal
They
people.
just left that out.
You know,
Well,
but
left
isn't
that
that
one
the
out.
most important thing? Like, I mean, we tried to get the court, the government wanted to get that through with the children's stuff, and it fell at the hurdle. So,
Disappointing.
yeah,
But
but it's in now.
well done.
Yeah.
Well done on everyone for getting this through.
Yes.
And we look forward to seeing how it goes through and how this happens and helps you. So
Yeah.
if it's affecting you now, if you're noticing the changes now, we'd love to hear from you at the Divorce
Please
Course
do.
Podcast at gmail.com. Send us a message. Of course, our Q&A members every week, they're keeping us updated on what's happening in the courts as well. But we'd love to hear from you if you've got any tips. And what do you think about it? Let us know.
Yeah.
I'm going to put a poll up on Spotify. If you're on YouTube listening to this, you can tell us, what do you think about the changes? Do you think they're going to help or are they going to hinder? Because we've had some interesting perspectives.
And please like and subscribe on the YouTube because, really, I was talking to a lady yesterday and she only accidentally came across us. So if we've been helpful to you, if you can just help us get to more people, it's just help people, okay?
All right. Thank you so much, everyone, for listening, and thank you, Mum, for your time today.
Bye-bye, Laura. Bye, everyone.
Bye.
Have a good day.
If you found this podcast helpful, we'd love it if you could rate, review, and subscribe. By doing so, you are spreading the word to help someone else just like you. Lynn would like to remind you that this podcast is general advice only, and you should always get legal advice in relation to your particular situation. And remember that the Australian laws may have changed since recording